We're going to get started, so if you could all have a seat, that'd be great. All right, first of all, thank all of you for being here at 8:30 in the morning after a night in New Orleans. It shows true dedication. I really appreciate it, and so does the panel members. It's great. And we have an excellent second day for you. There are issues that are being raised today with source and economists, and then we have some basics that we're going to be talking about today. It's an excellent program, so thank you all again for being here. And we're going to start off today with our program, Determining Source of Exposure. Is it the house, something else, and what to do if you can't tell? And we have a great panel here today. We have Nick Sicoli from the Law Office of Evan Thallenberg. He's been litigating these cases for years. He is a master of motions and an expert in experts, and you're going to get great insight from him today. You have Dave Governo from who brings us years and years of experience in toxic tort and lead litigation. If you've been to these conferences in the past, you know Dave is a regular speaker as well. He brings insight from the defense perspective concerning issues determining source and lead cases and toxic tort cases in general. We're very lucky to have him here today. And we have Vince Coluccio, and forgive me if I'm pronouncing that incorrectly, and he's going to give us his insight from an environmental health consultant perspective. He has all kinds of diverse experience, not just in lead, but in all areas of environmental exposure, toxic exposures, toxic torts. He's going to be extremely informative. I know the panel has put together a great program for you, so I'm going to sit down and let them get started.
Is there a trick to this? I'll get started. Good morning. It's an honor to be invited to present at this excellent conference. My background is in public health. Since 1988, I've been providing lead-based paint risk assessment services to property owners and managers. And during that same time, I've also served as an expert on lead exposure assessment in about 700 childhood lead exposure cases. Most of my cases were in New York, New Jersey, Pennsylvania, Massachusetts, to a lesser degree in North Carolina, Alabama, and Georgia, and some other states. Nearly all of these 700 cases hinged on the testing, the lead testing of public health and public housing agencies. And these agencies are required to follow the EPA regulations at CFR Part 745 and the applicable parts of the Hud Guidelines. Basically, what these regulations and guidelines want to see is that there is empirical evidence for bioaccessible lead, and I'll sort of define that, in the form of paint chip analysis or dust lead sampling, that there is lead in a child's environment that a child can be exposed to and can inhale and ingest. So as a risk assessor, that's the bottom line. I'm looking to see if there's evidence of those hazards. Unfortunately, many of these public agency reports fail to comply with the guidelines and the regulations, and do not, even though lead hazard violations are being issued, do not provide evidence of bioaccessible lead. What my presentation will do is provide some illustrations of examples of these non-compliance problems that I've observed in the past and I continue to observe today. I'll also talk about some of the consequences of those non-compliance problems. I'd like to state up front that I'm an advocate for providing agencies with the resources and the training and the oversight to do this work properly, and I think progress needs to be made there. Okay. Still having problems.
No, it's working now.
Oh, okay. This is a photo I took in 1990, and it shows the Princeton Gammatech XRF. So we're going to look retrospectively for a moment. This was the instrument that was prevalent beginning in the 1970s, 80s, and into the early 90s. It was widely used. And at the time that I got involved in 1990, EPA and HUD said that if you're using this instrument and you come up with readings less than 4.0, you must do substrate correction on those readings. So I'll try to explain what that means. Here's an XRF, assume that's a Princeton Gammatech. It's putting radiation through paint films, and it's giving you a measure of the lead in the paint film. But with this particular instrument, it's also picking up readings from the substrate, whether it's a metal cinder block or other component in a home. Even in the absence of any lead in the substrate, the instrument is increasing its reading due to the density of the substrate. So in order to get an accurate reading, what EPA and HUD say you have to do is you take 3 readings on the same spot because there's a little variation. You need to obtain the substrate value and subtract it from the paint readings. What that requires is you take a scraper, you remove the paint, and you test just the substrate. You'll get a reading, and you subtract that because it has nothing to do with lead in the paint, and then you get a corrected reading that way, and you average the 3 readings. If you do a corrected reading and you come up with a 1.0, which is 1 milligram of lead per square centimeter, translated, it's 1,000th of a gram of lead in the size, an area about the size of your pinky nail, that's lead-based paint. Unfortunately, most health departments that I'm familiar with were very loath to go and scrape paint in people's homes because, number one, you're damaging the surface, and number two, if there is lead in the paint, you'll be spreading lead dust if you don't do it properly. Now, there were procedures to do it properly, but most of the health departments I'm familiar with did not do it. And as a result, they just reported the raw data, the uncorrected data, which, you know, these 1.0s and these even up to 2 and 3 and 4 milligrams of lead per square centimeter were cited as violations, and in most cases, and a lot of them would drop out if you did the substrate correction as you're supposed to do. Here's an example of a New York City Health Department report with 2 readings of 1.2, 1.5, and you'll see that these are not corrected, and laboratory analysis showed that they contained just trace amounts of lead, nothing like lead-based paint. I was a sort of an informal advisor to the health department at the time, and I explained this problem, and they agreed that, yes, using the Princeton Gammatech without substrate correction was inflating values, and what they decided to do was continue that practice, but give owners and managers the opportunity to contest those findings by taking paint chip samples, which always trump XRF readings if you take the sample properly and you have it analyzed properly. And what they found was that 60 to 70% of these readings that came in under 4.0 with the uncorrected readings turned out to be not lead-based paint. And what the city found out was, you know, just what HUD and EPA were saying, that this instrument has, it's a good instrument if you use it properly, if you do the substrate correction. If you don't, you're getting inflated values. So that's the past. Here's the current. Here's another instrument we're currently using. This is the LPA1, which is a good instrument. Again, nothing wrong with it. It's a fine instrument. But in this case, there are 11 readings, all at 1.0 milligrams of lead per square centimeter. So that's wanting me to believe that there are 11 painted surfaces with exactly, since it's 1.0, 1/10,000th of a gram of lead uniformly on metal surfaces that were painted. And that's impossible, because when you paint, the mere act of using a paintbrush does not leave a uniform layer of paint that's going to give you the same reading. What's going on here is that these 1.0 readings, it's an operating characteristic of this instrument that if it can't read the, if it can't give you a reading with the exact precision and accuracy that's required, it gives you a default inconclusive reading. And if you use the instrument properly, you say, okay, I know this is not the real number. We can go ahead and do paint chip sampling or some other way of coming up with the real number. But to present these values as lead-based paint and then to issue violations based upon them is inappropriate and results in many false positives, especially on metal. The instrument is more likely to create these inconclusive default readings on metal surfaces, even in the absence of any lead paint. And again, we tested this and found no lead-based paint. So these are examples of an ongoing problem with substrate correction. I was at a meeting going back a number of years, and I was presenting on this topic, and a gentleman stood up and sort of took me by surprise and said, these numbers don't matter whether it's a 0.5 or a 1.5. Something along the lines of the housing sector created the majority of lead poisonings and they should pay to correct the problem, and he went on and on. And what he was reflecting was this like ideology that it's okay to err on the side of public health and that these nuances are not very important. And you know, I took issue with him. I find no basis in the regulations for that approach. I also don't think it makes a lot of sense. The consequences of these false positive violations that have occurred for decades now is quite considerable. Number one, it represents a misuse of agency resources, and there's a public health imperative here, because when you have a false positive, you create an impression that the hazard was identified and we're going to take care of it, when in fact there might not have been any hazard whatsoever there. And what that does to resource-strapped health departments is it cuts off the rest of the investigation at a time that's contemporaneous with the child's elevated blood lead level. It's the worst time to stop looking for the actual source. And I've just seen many examples of that. This kind of false positive reading also results in unwarranted legal liabilities and abatement costs and so on. Now, I'm not aware of any study that's been done on this, but being in the field for a long time, you know, I feel very certain that these unwarranted costs range in the tens of millions of dollars, just looking at the areas where I'm concerned. But considering how many of these instruments were used and how many health departments followed this practice, it wouldn't surprise me if the unwarranted cost went into more than tens of millions of dollars. This is not just you know, looking back at the past, it's the current issue, because a lot of these old reports are now coming through the pipeline and they're requiring, you know, analysis and review in cases. I have the sense that that ideology that was expressed by that gentleman is still expressed in, it's still sort of echoed in some of the practices of health departments. This is a Wilson-Elser case where a lead-exposed child, an XRF reading was taken here, found to be very high lead content, and it was assumed to be the source of the problem. I was able to come along and find that here's the lead-based paint underneath, the latex paint that was covering it. The lead-based paint was perfectly intact. There was no dust lead in the apartment. This lead-based paint is stuck on the wall tight. It's resistant to deterioration and so on. Basically, lead-based paint is a great paint in terms of the paint itself. Of course, it's toxic, but there was no toxicity associated with that, yet the hazard violation was issued and there was a liability there. Now, there's a second issue here, and they're related. I'm getting a number of cases, more and more, of lead-based paint findings on the exterior doorway of an apartment, either the door frame itself or the door, on these metal doors, as the only violations, and nothing else in some of these cases, and no other lead is found in the apartment. The Hud Guidelines will tell you that if lead is on metal door frames and surfaces, and it resides only in the primers, and the primers are factory applied in sound condition, the primers need not be abated or removed because it's stuck on the metal. It's not creating a hazard. If you don't take a paint chip sample as required by EPA to validate the presence of a bioaccessible lead condition, how do you know if the paint is on the exterior where there might be some surface abrasion on the paint, or if it's buried and if it's not a hazard? And the answer is you can't determine that. You must take the samples. And again, many health departments do not do that. They rely upon just the finding of a lead-based paint value as evidence, purported evidence of a hazard. We're not really finding this. This could be a little bit of a frustration for me, because in a trial situation, I will try to explain that, yes, there was lead-based paint there, but no empirical evidence was provided for the presence of a hazard. And oftentimes, I find that the court defers to the health department because they're the experts and that's their job. Another issue that I find with deficiencies in some reports are the calibration check readings. I'll read the bottom one, which is the current HUD guidelines. By the way, a new edition of the HUD guidelines came out about a month ago, much more detailed and has some interesting changes to it. But XRF readings that are not accompanied by successful calibration checks at the beginning and the end of the testing period are unreliable and should be repeated after successful calibration checks have been made. So before a lead inspector goes out and tests the wall, they have to take 3 calibration checks on blocks of known lead content before, and 3 calibration checks after. And if the calibration checks show that the instrument is operated properly, you're confident that the data are good. And again, oftentimes, I don't find calibration checks, or they're not a sufficient number. And it just really leads to the question of whether the XRF data are valid. Regarding dust lead sampling, as you probably know, the standard for a floor is 40 micrograms of lead per square foot. That's 40 millionths of a gram of lead in a square foot on a floor. And on a window sill, it is 250 micrograms of lead per square foot. There is not a dust lead hazard standard for window wells at the federal level, but there is a clearance standard after an abatement. You have to get it below 400 micrograms per square foot. The issue here is that HUD and EPA are considering whether to lower, number one, the threshold level for lead-based paint. That 1 milligram of lead per square centimeter current standard when you use the XRF might be lowered. My understanding is that HUD is not amenable to doing that because it would take many compliant properties and put them into non-compliance. But the other thing that EPA is considering doing is lowering the dust hazard standard of 40 and 250. And that's because these current standards are based on providing a 95% degree of confidence that a child living in an environment with lower than those levels will not come up with an elevated blood lead level. Now that we're coming down to a reference value of 5 micrograms of lead per deciliter of blood, the EPA is feeling that they need to lower the standards to try to accommodate the lower blood lead level. colleague of mine, Jack Caravanos at Hunter College, City University of New York, did some interesting studies on this, on the issue of dust lead in the city. And he tested the top of a number of traffic boxes and found these settled dust lead concentrations just from atmospheric deposition. And if, these exceed the indoor standards. Of course, we're not expecting children are going to go up there, but it does show that there is quite a burden of dust lead in the air. More interesting, he set up a number of these glass collection plates, and he put them in apartments that had no lead-based paint. And he opened the windows. He actually rented some apartments to do this. And he came back and calculated how much dust lead was being deposited just from the atmosphere. And he found a minimum of 1.6 on a plate, a maximum of 40.8, which exceeds the floor dust lead standard just by leaving the window open for a week. And he also found the median of about 4.8 micrograms of lead per square foot. So it sort of corroborates what a lot of us already know, is that when you find a dust lead hazard, where did it come from? Did it come from the atmosphere? Did it come from that settled dust being tracked in on feet, or did it come from paint that's in the apartment? I'm sort of looking futuristically now, and I'm thinking that with the lower reference value that we have and the concern for where did hazards come from, I think we're going to get to the point we're going to try to identify where dust lead came from. It's not really an issue if you're in an apartment with heavy content lead paint or any lead-based paint that's deteriorating. It's a no-brainer. You don't even have to go that step. But it may be warranted in situations where you don't have deteriorated paint, you have a dust lead hazard, and you can't figure out where it came from. I'm anticipating that we might even get to the point where we want to, or may find ourselves chemically and isotopically fingerprinting ambient dust lead, the dust on the floor, and the dust in the paint to see if there's a way of identifying the source of the lead. I don't know if we're going to get to that, but just looking down the road a bit, I could see that as being feasible. So I talked about the past, the present, and a little about the future, and I hope that was helpful. Thank you.
Good morning. So last night I was telling my wife, who is a phenomenal trial lawyer and also a great person, so I was a little nervous about this topic because I'm in a room full of skilled operators, and there are people that no matter what I say or evidence I present, they will deny that the earth is round. And I said, what do I do? And she said, close your eyes and just think of the two most stalwart, immovable people who will sit through your entire presentation with their lips pursed. Think of them in their underwear. And I went, wow, I feel a lot better. But then I felt so moved that I thought, since we were in the Big Easy, I should get my friend Mark some beads. Thank him, because I saw so much of him. And same for you, Pat. Thank you very much. Got you some beads as well. So let's talk a little bit about circumstantial versus direct. You'll notice that I managed to sneak one by the litigation group when they had the topic for our presentation. And you'll notice it says circumstantial versus direct, a distinction without difference. I don't know if nobody caught it, but I'm happy they didn't, because it's true. And it needs to be the marching order of our side of the V. The fact is, there's no such thing as direct evidence of the source of a child's lead exposure in 99.999 bar repeating lead paint cases. Why? Every test that was done for lead happened before or after in the house. That requires an inference. If it requires an inference, it's circumstantial evidence. Now that's why I believe, and there's a few other people that believe, that pretty soon the Court of Appeals may take this issue up and may have to say, that dicta that keeps dragging around from that case, yeah, that's not good law. The fact is, circumstantial evidence is how you get from A to B in a toxic tort. I don't know. I don't have a red bathrobe, so it doesn't mean I'm right, but I think it may happen. So let's talk a little bit about what I view as building your arsenal when you talk about a circumstantial evidence case. So, without much ado, rate of decline in excretion literature is everybody's favorite topic, as long as your house is the second one. Helpful clues in the medical records, something we're going to get into a little bit there, and I'll warn you, we're going to get nerdy. Siblings, correlations between sibling blood level literature. I'm sad to see my friend Tom Whiteford isn't here, because he and my colleague John, who probably is wearing dark sunglasses and still in bed right now, we had a 2-day hearing in front of Judge Carrion over most of these issues, but especially sibling correlations. And I think that is such a piece of low-hanging fruit that perhaps people on both sides, but certainly plaintiffs' counsel, can take better notice of. So let's talk about the kinetics of decline. I was happy to see, and I don't know if Dr. Scoof, there she is back there, we talked about this a little bit yesterday. And by the way, I have told people that that presentation you gave yesterday was one of the most data-rich presentations we've had at these conferences. So thank you very much. But the toxicokinetics of decline, I wish there was a better answer. All we can do is look at studies that some of which are admittedly imperfect, and we can try to extrapolate out. Now, an old favorite is Roberts-Reigart. This is and the citations for all these articles appear in the handout materials. 579 patients split up into different cohorts. The conclusion was the number of months to achieve a blood lead below 10 was 0.845 by the peak lead. If you don't have that written on a Post-it note and taped to your computer screen, you should. Both for the plaintiffs and the defense, it's not perfect. And there are 1,000 reasons why it may not apply in your individual case, but it's something to at least know about. Now, worth remembering, the children in this house, and my friend Barry there actually had hired Dr. Reigart to testify. I don't know if he's retained in your current case now, but Dr. Reigart readily agreed the children in his study were not living in lead-free or lead-safe housing, just hopefully less worse than they were living in before. The typical treatment regime in that study was the health department going out and doing that which they do already, which, hold on to your seats, was not Mexican candy or canned foods. It was addressing the house and advising cleaning and follow-up literature. Now, the time for decline to 50%, the survival line was not linear, and it varied by lead level. It's very important to remember. Your individual lead level, your individual case may not correspond to the curve there. It's just a rule of thumb. It's just something to consider. I know Dr. Scheller looks at the TLC study and their rate of fall literature. Also problematic because, as Dr. Scheller willingly agrees, the issue with the housing in the TLC study, sorry Barry, is that it's not all uniform, and we don't have the exact kind of information we need. What we need is to take a group of kids, maybe 579, put them in lead-free environments, as difficult as that may be to do, and then watch their rate of fall. And we don't have that literature, so we have to extrapolate out the best that we can. Now, one thing that I think is always important to remember when you talk about the rate of fall in a child is the situation is dynamic. There's more to it than just X or Y. The absorption rate changes, and I saw a paper that the doctor had edited for the Navy back in 2000, and there were some great points in there, things that I haven't actually read yet. There's a swine study, I guess, about the intake and bioavailability of lead in soil, things that I need to read as well. That's why I love coming to these things. But children absorb lead faster. They have a more efficient GI tract. So put differently, the same bolus, the same amount of lead in a child gets absorbed at a much faster rate than it does in an adult. They're just more efficient. That's how they operate. You also have to remember that this is the actual ATSDR children from infants to age 8, and I think age 8 might be a little bit of a wide parameter, absorb 40%, 50% of ingested lead. Estimates of absorption in adults ranges from 3 to 10%. We're just not that efficient. Normative blood levels peak between 18 and 36 months and go down, and reflects the changing dynamic of decreased intake, which is the hand-to-mouth behavior, as well as the decreased absorption. So that funnels back to the point that I made at the beginning of this slide. It's a dynamic situation. So it's not that just because the child's lead level has gone down, aha, ergo they must not be exposed. It's more nuanced than that. What's the age of the child? What's the hand-to-mouth activity? How has the child progressed developmentally? You could look at a child with the exact same ingestion rate, not exposure, ingestion rate, and still have the lead levels going down over time. Now, there's actually an article by Schoenfield in Pediatrics of 1963 that talks about the declining hand-to-mouth behavior, normal stage of development. I think that's pretty well settled, but if anybody needs the reference, I included the materials. Bellinger in Pediatrics 2004 made the same point. that hand-to-mouth activity is the increase, is the source of the mechanism of lead ingestion. So, clues in the medical records. This is where we get a little nerdy. FEP. Nobody likes to talk about FEPs anymore. And I came in, admittedly, when FEPs were transitioning out. Yes, there is a sensitivity problem. Yes, there is a specificity problem. But it doesn't mean it doesn't exist. And there are lots of doctors that, if you ask them, probably off the record, you flip their notes over, they've been tracking the FEPs. I know for a fact, I think Siebert still does that, and I think Dr. Scheller had told me he did that. It's just one of those things. It's another piece of information. And there is no, if these recent tumult in the Court of Special Appeals has taught us anything, there is no magic language, there is no gold standard. It's just evidence. And so if you are the plaintiff, or maybe if you're the defense and it's a certain kind of case, it behooves you to get as much of it as possible. So you look at these things like EPs. Measurements are also useful in the follow-up of the effectiveness of long-term therapy. I know that in the case that I had with Barry, that was a big issue. We talked about that a lot. And it was people that weren't afraid to jump in and talk about the science as they saw it for fear that they may be used against them in the next case. And so we all learned a lot about EPs, or erythrocyte protoporphyrins. So the caveat for that is it reflects a myriad of other conditions on hemosynthesis, like iron deficiency. And by the way, these charts, I'm not saying take them to the bank, but I did clear them through a Johns Hopkins pediatric hematologist who assures me that they are accurate. So take that for what it's worth. So on the right-hand side, and you don't have to jot it down, that's kind of a figure of speech. This is actually in the packets. I've got the back of the napkin math for the reference ranges for the erythrocyte protoporphyrins, depending on which way it's expressed. One thing to keep in mind is to watch, especially on those older Baltimore City Health Department records, you get all the kids glommed together. Now, clinically, that's inaccurate. The children have different reference ranges depending on their age. But if you look at the health department lab slip on the bottom, they don't have tranches by age. It's just class 1, class 2, class 3. So if you peel the onion back a little bit, like most things, it's nuanced and there's a little bit more information that can be had. Now this is a very atypical example of one that a medical expert picked up in one of my files. We had a problem where we had, and we're going to get to this, we had a sibling issue where we've got one sibling who is basically Davy's lamp. This sibling has a high elevated lead level. The other sibling doesn't have a proof of absence. There's an absence of proof. For whatever reason, whether it's the issue that we've dealt with a lot, I think GBMC or some of the medical clinics torched all their records, or they got sold, or whatever it was, we just couldn't find lab slips. And so we had to go through this kid's medical records. Luckily, we had lots of CBCs, we had lots of regular checkup data, and the expert pulled some things together. One of the things that he pulled out was sideroblastic anemia. Now, sideroblastic anemia, if you look in the picture there, the blue dots around the outside of the sideroblast, those are little granules of iron that the cell couldn't absorb. So you have excess iron kind of floating around. The indicators are an increase in ferritin protein, a low mean corpuscular volume, which is the size of the red blood cell, and a lower crit, which is the percent of red blood cells. You take those things and put them together. Can you go to trial on this? Only for the brave, I think, but it's something to put in the quiver. It's additional information to have, and that is how we as the plaintiffs bar have to answer these challenges with regards to, is the kid being exposed while living at a certain house? 2 minutes? Okay. All right. Correlation between sibling blood lead levels. Excellent, excellent, excellent literature on this. Robust data covered in all kinds of different areas that we wouldn't have necessarily thought. There's one, it's a foster care study, is one of the most interesting, I think, to me, where they take one kid that happened to go to foster care and they follow the other kid that wasn't removed. And the kid who's in foster care's lead levels go down, they move him back to the house. Guess what? The kid that goes back to the house all of a sudden has about a 2.4 times more likely to have a lead level of 15 or higher. So they're talking about using the information, the biomarkers you have on the child still in the house as a reference for exposure. And that's something we all should really be thinking about. Now you may have noticed, and doctor, it was not your fault at all, but when you said yesterday that clinicians probably weren't trained to talk to people about lead I almost fell out of my chair because Baltimore City pediatricians have been doing that for probably 30 years. There's a standard risk questionnaire. This protocol they have for talking to families about childhood lead exposure is very robust and very well developed. Part of that is this risk questionnaire, and one of the questions is, does your child or brother or sister have a lead level over 15 who's being followed? In this study of Schaefer, the reason they included it was because that was the single most likely indicator of a child with an elevated lead level. And the only other one that had a positive correlation, chipping, peeling paint in the home. Not occupational exposure, not the house down the street, chipping paint in the home where they reside. So we can deny that the earth is round all you want, but that doesn't make it so. That's it. Thank you very much.
Hey, good morning. My name is David Governor. I'm very pleased to be addressing you this morning. I've got about 10 minutes to address the issue of admissibility of evidence having to do with the source of lead exposure. And what I want to do is take a couple of steps back and look at this litigation from the big perspective, because I think it's very easy to get, focused in and excited about some pathological slides. But what I want to focus in on is maybe a little bit off the topic, but the complacency that trial lawyers get when they do the same litigation over and over again for year after year after decade. And what happens is I have to really thank Pat and Brian for a terrific organization of a presentation and a conference here, because the inclusion of the appellate issues, I think, is just fantastic and added a depth and perspective to this conference that, is really excellent. But what we get is complacency, and we get a failure to challenge the assumptions that everybody has been operating under, because the last time somebody tried to challenge the assumption, the judge shot it down, so they say, oh, well, that's a loser of an argument, I'm done with it. And I would challenge you all to be creative, to be successful by giving your opponent a little bit of fear. Now, from the defense side, in a lead poisoning case, you wonder, fear? How am I going to instill fear in a plaintiff's attorney, because I'm the one who's afraid? But you can do it. There are soft spots in every case on either side, and your job as an advocate is to find that fear point and instill it, and if you can't find it, you can make it. And the way to make it is to challenge some of the things that people have been assuming nobody's going to challenge all the time through. And I'm going to talk about a couple of these and hopefully give you some tips. One of the things that, I like to start at the basics. Keep it basic. What are your themes? What are the admissibility? Can you challenge admissibility? A lot of times it's not the real technical 25-page briefs, but it's what Nick and I were talking about earlier. It's the one-page motion in limine where you're going to eviscerate his whole case because you're going to keep the mother from testifying because she has no actual basis for saying the stuff that she's making up. And you can prove it. So what is the evidence? Well, it's a truth versus perception, and we heard that so well from our mediator yesterday in terms of if you're looking for absolute truth, talk to the theologian. You're not going to get it in court. What you get is a perception of the truth. And it's your work of that perception of the truth and melding it into your theory of the case, and you're melding it into what the jurors are going to understand and accept and believe that makes the difference between winning and losing these cases. The types of evidence, you got words versus things. In my book, the things trump the words every day. You've got to get the actual physical stuff, put the words into graphics so that the jurors can understand where you're coming from. And in terms of expert opinions, what we're talking about here is where did this particular child's blood lead level come from? Let's go. We got a balky relevance. Well, it's basic legal rules, but my point here is what's the purpose of what you're trying to admit this evidence for? It's going to say something, but what are you trying to make of it? What's the inference that you're trying to get the jury to draw from that particular piece of inference of evidence? And your challenge is to translate the technical stuff that you get from Dr. Coluccio about the empirical evidence of bioavailable lead. That is not a line that's going to ring real well with your jury. I don't care where you are. You've got to translate that into how did this lead in this kid get there, and was it from this house, or was it from the soil, or from the water or from the paint or the cans of food, or where was it from? And what we found from the toxicologist yesterday, who talked about as the lead levels go down, I think the quote that I wrote down was, there is no single source of lead that predominates in the exposure. And that means you can look at soil, you can look at water, you can look at all of the other sources, because what we're talking about is a very, very small amount of lead. Here we go. This is my favorite slide. What you're basically talking about with these documents that you get, that Dr. Coluccio was talking about, is hearsay. Unless you've got the guy who did the testing there, what you've got is an out-of-state court statement used to prove the truth of the matter. How do you get around that? Business records exception, public documents exception. The key here and I try to refer you to the paper that I've put in the materials, because it gives you the citations to all the rules and everything else. But the key here is that if you use the public records exception to the hearsay rule, you can try to sneak in some expert-type opinion evidence if it is reliable and trustworthy. And that's what I would challenge you to do, is look for ways that you can challenge the trustworthiness of a particular document. What we're talking about here isn't there's lead in the house, there's lead in the kid, let's talk about how much money. We're talking about where did the lead that is in this kid, assuming that you've got a bona fide lead test, that is not just a one-shot deal, where did it come from? And what I challenge you all to do from a defense side is to actually make the plaintiffs go through the process of proving not that it was just there, but that it was available to be ingested at that particular time, and then challenge the quantities. Because what we didn't hear about was the Maryland case of Dixon versus Ford, where the actual opinion evidence was, expert said in an asbestos case, any amount of exposure is substantial because it's all substantial, and she did not quantify that level of exposure at all. Maryland Supreme Court said that's not good enough. You've got to give the jury some help in defining whether an exposure was substantial. And I would challenge you all to put the plaintiffs to the test, put their experts to the test. What data do they have to quantify in any way, even estimate the amount of lead that came from that particular apartment and ended up in that particular child? What we're talking about here is extrapolation on extrapolation. Obviously, the appellate presentation I thought was terrific yesterday, because as trial attorneys, we're always walking the fine line of pretending that that piece of evidence that we'd really like to get out doesn't bother us, even though it's killing us, and we want to object to it, but we won't want the jury to realize that this is a really important piece of evidence, so we don't want to. You've got to make that objection. You've got to do it in a way that is going to preserve the appellate issues, because otherwise you're just taking your chances, and that's just never, it's not a good risk. It's not a good chance. But what I would really focus on here is developing your theme of how are you trying the case, and how are you going to put this together. And what I would suggest, for example, a theme is that Nick here is building his whole case on extrapolation. I wouldn't even use the word extrapolation, I'd use the word guess. One guess after the next guess after the next guess, and we've got this house of cards that's ready to go over. And the guess starts with, where did the lead in the child come from? Was this lead that they found in the house, did it actually get into the child? What did it do to this child? What about this other thing that had the same effect on the child? You just work it into your theme. You put the theme together, and you make whatever evidence you can come up with on the point of the exposure work as part of your team, of your theme. And so that the probability evidence from the lead in other homes, from the lead in the sibling, from all of this is just, I would portray it as the plaintiff's attorney stretching, try to make a case out of nothing, and there's really nothing there but speculation and guesswork. And with that, you sit down and keep your fingers crossed. Thank you very much.
Okay, we did get a question for Dr. Coluccio, and they're very similar, so I think I'll read from this one. Doctor, aren't the HUD risk assessment guidelines simply a suggested way of assessing the risk of lead exposure, I'm changing the word poisoning to exposure, in public housing projects? Local public health agencies don't have to adhere strictly to a guideline that is not a law or regulation, do they?
It's my understanding that the HUD guidelines are referenced in the EPA regulations and in most state and local codes.
That's my understanding as well. Okay, any other questions? Anyone? No? Okay,
Great, thank you.
thank you.
Thank you.
We want to be cozy.